Okay. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what is called an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishments because, as I mentioned to you, your case is a misdemeanor case. And misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. Cannot be given jail time, and the fine cannot be above or cannot exceed $500. Now, however, if a person failed to pay the fine, but the fine was converted to community service, and they failed to perform the community service, then the court can issue what is called a capious pro fine. That just simply means it's a warrant for the person's arrest for them to either pay the fine or sit the fine out in jail. And if they sit the fine out in jail, for every 1 day that they spend in jail, they'll receive $100 credit toward the payment of their fine and court costs. Now, Class C misdemeanors are cases that start in the JP court or the city court. For example, not having the seatbelt on, speeding, having an expired license tag. Those are commonly referred to as Class C misdemeanors. They come to this court when the person pleads guilty or is found guilty or they plead no contest in the JP court or the city court, and then they appeal the case. An appeal is they want to hold new trial. And so they get a whole new trial. Comes to this court, and the punishment range stays the same. Fine on, and the fine cannot be above $500. Okay. Now, the next highest misdemeanor is a Class B misdemeanor. And with the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days or 6 months in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and the fine. The highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year, in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such jail time and the fine. Now, you may be eligible for probation. Now, there are two types of probation. One type of probation is called unadjudicated probation, unadjudicated probation. And the other type is called adjudicated probation. Okay? The difference between unadjudicated probation and the adjudicated probation is as follows. With the unadjudicated probation, it does not result in a conviction on the record. And if you successfully complete the probation, the case will be dismissed. It will not result in a conviction on your record, and you may qualify for what is called a non-disclosure. But what a non-disclosure is, it basically means that your record will be sealed to the general public. Now the operative word is general public. Most of the public is the general public, but there are certain agents, governmental agencies, that can have access to your record. For example, the police department. They're listed in the Texas Code Criminal Procedure. They're one of the agencies that can have access, but most of the public is the general public. So the example that I always use is, for example, let's say you have a non-disclosure. And let's say you apply to a job for ExxonMobil. Okay? And they do a criminal background check. The case that you have a non-disclosure on is sealed. They cannot see that. Okay, because they're part of the general public. Okay, so that's an example of what a non-disclosure will do. Now, the other type of probation, which is different from unadjudicated probation, is adjudicated probation. With the adjudicated probation, we kind of refer to it as regular probation. It does result in a conviction on your record. However, there is something that is called judicial clemency. Judicial clemency means that the court, the judge, can set your conviction aside. It's almost like giving you a pardon, but the court can set the conviction aside, and you will no longer have this conviction on your record. Now, in order to qualify for that, three things has to happen. One, you have to successfully complete the probation. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged or let off the probation by the probation authority. If those three things happen, then the court has the discretion to set your conviction aside and give you judicial clemency. Now, however, if you get a subsequent conviction, that is, if you get another conviction later on after you receive judicial clemency, the case that you have judicial clemency on can be resurrected, revived, or brought back up, and it could be used against you. And if you try to get a license with Child Protective Services, CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Okay, now, everyone that's here for court today, you should have a clipboard. Who does not have a clipboard? Okay, everyone has a clipboard. I'm going to go over the paperwork that's on that clipboard. The paperwork that's on that clipboard covers the first right that I'd like to talk to you about, and that is the right to have an attorney. The first document should be titled Judge's Explanation of Rights to Defendants Without an Attorney. And the document looks like this. Okay, I'm going to go over this document with you, and I'm going to constantly refer back and forth to this document. Okay, now this document states that as a defendant in a criminal case, you have three options. You'll see 1, 2, 3. And that is, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first one sentence paragraph below number 3 states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date from today to give you time to hire your attorney. Now, the next one sentence paragraph below that states that if you want an attorney, but you do not have enough money to hire an attorney, then you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, a financial questionnaire is a 3-page document that is on the clipboard. It is titled Jefferson County Affidavit of Indigence, or maybe just Affidavit of Indigence. It's on the clipboard now. You will only fill this document out if you are requesting a court-appointed attorney. So if you're not requesting a court-appointed attorney, you don't have to worry about anything that I'm getting ready to say about this document. Okay? So this is only for people who will be applying for a court-appointed attorney. And so for those individuals, they would have to fill out the first page of this document. And then you'll go to the second page. And on the second page at the top is titled Defendant's Oath. You'll fill out this portion that's titled Defendant's Oath. And then you'll fill out the middle portion that's titled Unsworn Declaration by Defendant. And then you'll stop. Okay. Going back to the first document, that's titled Judge's Explanation of Rights to Defense without an Attorney. The third one-sentence paragraph is for individuals who will be representing themselves. That is, they will not be applying for court appointment, they will not be hiring an attorney, they'll be waiving or giving up their right to have an attorney to represent them, and they will be representing themselves. Now, if that is what you're going to do, then before you can, well, if you represent yourself, you'll be your own attorney. And just like the attorney, if you had an attorney represent you, they can talk to the district attorney. You'll have the right to do the same thing. Now, we have 3 assistant criminal district attorneys in the court and call them prosecutors. If you're representing yourself, you'll have an opportunity to talk to one of the 3 prosecutors to see if you can work out something on your case. Now, before you're able to do that, you have to first sign a waiver of your right to be represented by an attorney. Now, this is only for individuals who will be waiving their right to an attorney. And the waiver is a 1-page document that is also on the clipboard. It is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding Trial. The document looks like this. Okay? And this is only for individuals who will be waiving their right to an attorney and represent themselves. Now, the next paragraph is in block form on the judge's explanation of rights to defendants without attorney. It's in block form. It's right here. It's stated this for individuals who will be representing themselves. It says that as a defendant in a criminal case, you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of firearms, housing and public benefits, and child custody. Now, if you are waiving your right to an attorney, the last 1-sentence paragraph right here at the bottom, it states that you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, what this means is that if you're representing yourself, you may change your mind and say, well, I want an attorney to represent you. You can change your mind and request that an attorney be appointed to represent you. Or if you can't afford to hire an attorney, you want to hire your own attorney, you can hire your own attorney as well. So this paragraph is saying that, for example, let's say you represent yourself. And let's say you want to talk to the prosecutors. And let's say you have in mind that you would like to get a fine, okay? And they say, well, no, we're gonna offer you probation. You say, well, I changed my mind, Judge. May I see if I qualify for a court-appointed attorney? I would like to hire my own attorney. So you can change your mind again. All right. Now, at the bottom of this document, everybody's gonna make a choice. Everybody that's here is gonna make a choice. You're gonna make one choice. At the bottom, in bold letters, it says defendant's choice. Mark initials next to only one choice. So if you are requesting to hire your own attorney, you will place your initials on the first line to the left. Sign this document where it says defendant, dated today's date, May 26th, and then you'll stop. And it's the only document that you will have to sign. Okay. If you have already hired an attorney to represent you, then you'll place your initials on the second line at the bottom to the left. You write the name of the attorney on the line to the right. You'll sign your signature, date, May 26, 2026, and then you'll stop. This is the only form that you will have to sign. If you like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left at the bottom. You'll sign your name where it says defendant, dated today's date, and then you will go to this next document that is titled Affidavit of Indigence. You have to fill out the first page of this document, and then you'll go to the second page. You fill out the top portion that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by a Defendant, and then you'll stop. If you have already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line at the bottom to the left, the name of the attorney on the line to the right, sign at the bottom where it says defendant, the date of today's date, and stop. And this is the only form that you would have to sign. If you would like to represent yourself, that is, waive your right to an attorney and represent yourself, then you put your initials on the fifth line, which is the last line to the left, sign where it says defendant, dated, and then you'll go to the document on the clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You'd have to read, sign this document, date it, and then you'll stop. Okay. Do we have any questions? All right. Now I'm going to go on and explain to you some of the rights that you have. We're going to give you an opportunity to fill out that paperwork. Now, the next right that I'd like to talk about is, well, first of all, before we do that, you can enter a plea of one of three pleas. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. Now, you have a right to have a trial by jury. That area over there where you see those 12 chairs, we call that the jury box. Because we're in county court, 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence that's presented by the state and by the defense. They will listen to the arguments of the state and the defense, and then they will go back into the jury room to deliberate, to decide whether to find you not guilty or guilty. You also have a right to waive or give up your right to have a jury trial. By waiving or giving up your right to have a jury trial, that simply means that you will not be having a jury trial. Now, you still can have a trial. You would have what is called a bench trial. That is, a bench trial is a trial by the judge. The judge will be the judge and the jury. And the reason why they call it a bench trial is because the judge sits on the bench. So the judge will be the judge and the jury in the case. The judge will listen to all the evidence that's presented by the state, the evidence that's presented by the defense. The judge will listen to the arguments of the state, the arguments of the defense, and the judge will apply the facts to the law and decide whether to find you not guilty or guilty. Now, you can waive or give up the right to have a jury trial. Now, if you do that, I mean, waive or give up the right to have a bench trial. Now, if you do that, basically, you waive your right to have a jury trial, you waive your right to have a bench trial. That simply means that you enter a plea of either guilty or no contest. Okay? And so, if that's the case, then you'll have an opportunity, your attorney or you, if have an opportunity to work out a settlement on the case. We call it a plea bargain. Now, if you're able to work out a settlement, we call that an agreed plea bargain. It means that you and the state has come to an agreement. Let's say, for example, you wanted probation, the state is offering probation, you saying that that's what I want. We call that an agreed plea bargain. Now, before it's approved, it has to go before the judge to see if the judge will accept or reject that agreement. Now, if the judge rejects your agreement, then you can say, well, judge, since you rejected my agreement, I take my plea back. And then that is, I don't want to enter a plea of guilty and no contest. The law says you have a right to withdraw your plea or take back if that happens. Now, if the judge does follow the plea bargain, then let's say within 30 days of the plea, you decided that, you know what, I think I've been wrongfully convicted, a court committed error by convicting me, and I would like to appeal my case. You have to get permission from the judge that followed the plea bargain agreement to appeal your case. And if the judge gives you permission, what's going to happen is your case is going to leave this court, it's going to go right upstairs to the Ninth Court of Appeals. There are 4 judges on the Ninth Court of Appeals. They will review your case. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court, or to this court to give you a whole new trial. Now, if they deny your appeal, guess what? You can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals, and they are located in Austin, Texas. Now, you'd have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means by myself, I represent myself, and I'm petitioning on the asking the Texas Court of Criminal Appeals to review my case, to see whether or not my appeal should have been granted, or see whether or not this court committed an error by convicting me. Now, they can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. If they deny your petition, then at that point, your conviction will stand. All right. Now, you also have a right, if you're in the state that's unable, you want to enter a plea of guilty, no contest, but you're in the state that's been unable to reach an agreement. Okay, you on probation, they ask you for jail time, whatever. Then you say, well, you have a right to do what is called an unagreed plea bargain. That is, you can't reach an agreement with them. You can go to the judge to see and ask the judge to set punishment in your case. We call that an unagreed plea bargain. Okay. Now, you also have a right to have witnesses to come to court. Witnesses sit in a chair that has the microphone in front. We call it the witness stand. And what witnesses do, they can testify either for you or against you. If you're representing yourself, if you can ask a question, or if you have a lawyer, your lawyer can ask a question. We call that either direct examination or cross examination. Now, you also have a right to waive or give up your right to have witnesses. Now, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have a right to have what is called discovery. And I'll explain that to you. And what discovery is, you have a right to have access to the file that the state has against you. That's you have a right to have access to the evidence. You have a right to see your statements, witness statements, lab reports, police reports, photos. You have a right to see video recordings, listen to audio recordings. You have a right to have access to any documents or instruments, whatever evidence that they have that they'll be using in your case. You have a right to have access to that. Now, you can waive or give up your right to have discovery. And if you do that, that just simply means that you would not be having access to that evidence. So I guess, let me use the word discovery. I guess you have a right to discover or see the evidence that the state has and will be using against you in your case. All right. Now, everybody that's here today, charges have been filed, you've been arrested, you've been placed in a county jail, you've bonded out of county jail, you're either out of jail on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you may be out of jail on a surety bond, which means that you pay a bondsman a percentage of the bond to get out of jail, or you may be out of jail on a pure bond or a personal recognizance bond. That simply means that you did not have to pay the money to get out of jail. You were just simply released under your own personal recognizance. I've said that to say this. Anytime that you spent in jail, that time or any day that you spent can be used as credit toward your punishment. So every day that you spend in jail can be used as credit towards your punishment. Now, the operative word is day. Okay, and I'll explain that to you. Let's say you were booked into jail at 11:59 p.m. last night. And let's say you booked out of jail at 12:01 a.m. this morning, 2 minutes later. That's 2 days credit. 2 minutes. The reason why it's 2 days credit is because yesterday was Monday and the day is Tuesday. It's 2 different days. Okay? And so you get credit for that. And so let's say you have 5 days in jail, and let's say you talk to the prosecutor, they offer you to serve 5 days in jail. That simply means that you would not have to serve any more time in jail. Why? Because the time that you spent in jail, you'll be given credit for the time that you want to serve. Now, if the state is offering 7 days in jail, you spent 5. That means you don't have to spend 7, you only have to spend 2 because we'll subtract 5 that you have from the 7 and 2. Now, you'll be required to, so you'll have 2 days credit. Now, let's say the state, let me explain this to you. Now, every day that you spend in jail, you're also credited $100 per day. So for example, you spend 5 days in jail, that's $500 credit that can go towards your fine and court cost. And let's say the state is offering you fine and court costs of $500. That simply means you won't have to pay anything because the time you spent in jail has already paid it off. Therefore, it'll be taxed and retired. Now, if they're offering fine and court costs of $700, that means you would have to pay $200. And you have to pay $200 on the day that your case is taken care of. If you cannot pay it, no problem, because we can put you on what is called a payment plan. You can pay it off in small monthly installments until it's paid off. Now, if you are unable to pay off on a payment plan, no problem, because we could convert your fine and court costs to community service. If for every 1 hour of community service that you perform in a nonprofit organization, $12.50 will be credited toward the payment of your fine and court costs. So in our scenario, if you work 8 hours in 1 day, that's $100. That's going to go toward your fine and court costs. So in our scenario, if you work 2 8-hour days, that's $200. Your fine and court costs is paid off. All right. Now, Jefferson County has a program for people who have not had cases filed against them before, 1 or more cases. The program is called pretrial diversion. With pretrial diversion, and when I say Jefferson County, I'm talking about the district attorney's office, they will dismiss the case. They will dismiss your case. after you complete the program, and you can get it expunged, which means erased, deleted, or wiped off your record, like it never happened. Okay, now in order to qualify for the program, three things has to happen. One, you have to get an attorney to help you with the application process. The attorney could be a court-appointed attorney, don't have to be hired, or you can hire your own attorney. The next thing, it cannot be an offense that involves unlawfully carrying a weapon or resisting arrest. And then the third thing, it could be one or more cases, which is these was cases was filed on you for the first time. All right. Now, Jefferson County has another program for veterans. If you're a veteran of any one of the branches of the United States military, the program is called Veterans Court. It's for veterans only. And with that program, you get in the program, you complete the program, they dismiss the case, and you can get it removed off your record as well. All right. Now, this court, County Court at Law Number 2, has a program. It's a program that God led me to start within the first 100 days of taking office in March of 2017. The program is called the CSI program. And CSI is an acronym that stands for Community Safety Initiative. And with that program is designed to address the issue of what we call recidivism. And what recidivism is when people commit crime over and over, it's just habitual, they continue to commit crime. And so with that program, the program is designed to address the issue of recidivism. And in that program, we have partnerships with various agencies in our community. And one of the agencies that we have a partnership with is Spindletop Center. We have some folks here from Spindletop as well as the Sheriff's Office. They're going to come to you in a few minutes and tell you a little bit more about the program that they have. Now, with Spindletop has the expertise to address your mental health needs. Now, you do not have to be incompetent or insane to participate in the program. You can just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address those issues. They have doctors, counselors, mental health deputies, as well as other personnel that they can use to address your mental health needs. Now, Spindletop here today, what they can do a private interview in our jury room, or they can do a private interview at their facility, or they can do it by telephone or by text, whichever is convenient for you. And they will be able to do an assessment. An assessment is they can determine what your mental health issue is. And then they can develop a treatment plan to address your mental health issue, either for outpatient or inpatient treatment. Now, Spindletop also has another program. It's a drug and alcohol recovery program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. And with that program, we also have a partnership with our local drug and alcohol council that has a similar program that is called OSAR, an acronym OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are alcohol and drug recovery programs, and what they will do, they will do an assessment. They will do a screening, then an assessment to determine what your drug and alcohol issues are. And then they develop a treatment plan for either outpatient and inpatient treatment. If you're unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, then they will help you to get a job in the area that you're trained in. If you have not graduated from high school, if you do not have your GED, well, they have a GED program. Spindletop has one as well as CICE. where you can get your graduate equivalency diploma. Now, all these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time. We take out time. And that simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individual that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned to you, just let us know. And we can direct you to the person and the programs that can help you to get on the right road to living your best life. So at this time, as I mentioned to you earlier, we have some folks from Spindletop. We have Tanya and our mental health deputy, the Butler. They're going to come to you right now and I'll tell you a little bit more about the program that Spindletop has to offer.
Thank you.
You're welcome.
Good morning, everybody. With Jackson County Sheriff's Department.
Yeah.
I'm also the liaison officer. Oh, great. The liaison officer with Spindletop. My part in Spindletop is to assist you with any transportation if you became a Spindletop client. Being transportation to your doctor's appointments back home. Also, you get caught up in a situation where you in jail and they'll assess you as a person who needs to be on top. You don't have a way home. We'll come to jail. We pick you up, take you to wherever you need to go to make sure you're there safely. Also, if you do so become a phone call client and you want to discuss whatever source that you're seeking for, you will do that with Ms. Latanya. She's a qualified mental health professional. Won't seek me on that part because I'm not qualified to discuss with you. Whatever's said between y'all is kept private due to the HIPAA law. And violate that, so whatever's said between her is kept between you and her and won't be leaked out. She usually will have something to say, but her voice is out, so what's more trying to say?
Judge Holmes. Judge Holmes, and Deputy Butler, very much like you have the details for you now. We can solve that for you can see that's the day, you can take call, email, every text for you.
So to translate that. A little form if you have, you wish to fill it out, you want to speak to someone with that, go ahead and fill out and listen on there with badge. So you can get back to the speak with you. Any questions? Oh, go ahead, go get it. More clear.
Okay, thank you, Deputy Butler and Tanya.
Thank you.
All right. Hope you did well, so. Now, ladies and gentlemen, the paperwork that you have on the clipboard, we're gonna give you time to fill the paperwork out. If you need help with the paperwork, we have our core personnel, including myself, will be happy to assist you with filling the paperwork out. Now, before I go any further, at the top of that document, at the top of the document, it says, State of Texas versus. Okay, you see, and it's a line. Please print your name on that line. Because if your handwriting is like mine, sometimes I can't even read. But so just print it so that we'll know who the paperwork is for. Okay, now we're gonna give you time to fill out the paperwork. Again, if you need any assistance, just let us know. We'll have our core personnel, including myself, who's here and available to help you with finishing or properly filling out the paperwork. Now, if you need to use the restroom, there are two restrooms right out in the hall. There's the men's restroom in front of county clerk number 3, which is right next door. And then on the opposite side of the hall, there's a women's restroom in front of the 172nd District Court. You'll be allowed to use the restroom. And then you can come back in court. Please do not leave the courthouse. You leave the courthouse. And we call your name. And you don't, and you're not here to answer. Your bond will be forfeited. Well, once your bond is forfeited, a warrant will be issued for your arrest. And you will be arrested, placed in the Jefferson County Jail. We have to bond out again. And guess what? We'll have to go through this all over again. So in order to expedite this, please come back into the courtroom once you finish using the restroom. Now, be mindful, we're still in the court. We're still in court. We're going to go into recess in a few minutes, but we're still in court, so conduct yourself accordingly. Okay. And if you have any questions, just let us know. Okay, so at this time, the court will be in recess. Jefferson County Court Law number 2 is back in session. Court is in session with its Raymond docket. First case is cause number 26 CCCR 0642. Case is styled the state of Texas versus Sadie Ryder. Mr. Ryder, would you please come forward? Ms. Ryder, your full name is Sadie B. Ryder. Ms. Ryder, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Ryder, you may put your hand down. How are you doing, Ms. Ryder?
Good.
I'm doing fine, thanks for asking. Now, Ms. Ryder, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for a court-appointed attorney? Ms. Ryder, I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes.
Ms. Ryder, before you signed and initialed these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Ms. Ryder, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you will be free to go, and you have a blessed day. Please stand in front of the court coordinator. Well, just have a seat in that chair. When she's ready, she'll call you. Willie Thomas. All right. Mr. Thomas, your full name is Willie Bruce Thomas IV. Mr. Thomas, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Thomas, you may put your hand down. How are you doing, Mr. Thomas?
Good.
That's good. Now, Mr. Thomas, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you have hired Rife Kimbler to represent you?
Yes.
Now, before you sign this document, did you read the document? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Thomas, your case will be reset. Let's see, you should have I see you have a felony case set on June 22nd. Is that correct?
Yes.
Okay. Is Mr. Kimbler representing you in that case as well? Okay. So, Mr. Thomas, this case will also be set on June 22nd, 2026. Now, on that date, what you need to do is check in with this court first. You'll check in with our bailiff, and then you'll go to the felony court. Okay. Once you finish in the felony court, then you come back down here to this court and let us know what happened in the felony court, okay, on that date. Now, before your case is reset, the bailiff is going to give you some bond conditions, and I'm going to go over these bond conditions with you. The document is titled Standard Bond Conditions in County Court at Law number 2. Do you see that document?
Number 2.
That's the title, Standard Bond Conditions in County Court at Law number 2. Do you see that title? Okay, I'm getting ready to go over these bond conditions with you, and it states following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim, and the alleged victim in this case is Lauren Mariah Thomas. Okay. And the defendant shall not go near any residence, school, or other location frequented by Lauren Mariah Thomas. Do you understand that condition? And condition number 4 does not apply. Condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Thomas, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Thomas, please take a seat in that first chair on the wall. Wait for your name to be called. You have it ready? Okay, just go to the coordinator window.
No, sure.
And once you get your case reset, you're free to go. And you have a blessed day. All right, thank you. Adrian Muniz. Mr. Muniz, you might have to pull your pants up.
Sure.
Okay. Okay, Ms. Muniz, your full name is Adrian Muniz?
Joel Muniz. Adrian Joel.
Oh, Adrian Joel Muniz. Okay. Ms. Muniz, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing?
Good.
That's good. Mr. Muniz, I have before me a document that is titled Judge's Explanation of Rights to Defendant Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that states you would like to hire your own attorney?
Yes, sir.
Now, Mr. Muniz, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in this document true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Okay, Mr. Muniz, I read your answers. Your case will be reset to give you an opportunity to hire your own attorney, but before your case is reset, the bailiff is going to give you some bond conditions that I'm going to go over with you. The document that she's handed to you is titled Standard Bond Conditions in County Code Law Number 2. Do you see that title?
Yes, sir.
Okay, and it states, following return of a criminal information in County Code Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location of the alleged victim. And the alleged victim in this case is that Nalia Garcia. Okay? Do you understand that condition?
Yes, sir.
Condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Munez, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
You have this paperwork. Now, Mr. Munez, you're gonna stand in front of the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day. Richie Lynn,
You put your hat right there with the wind.
Mr. Lynn, your full name is Richie Blaine Lynn.
Right.
Mr. Lynn, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Okay, Mr. Lynn, you may put your hands down. Mr. Lynn, how are you doing?
Mhm.
That's good. Mr. Lynn, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
No.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials
Yes,
on
sir.
the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
Now, Mr. Lynn, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Sir.
And is everything in these documents true and correct
Sir.
to the best of your knowledge? Mr. Lynn, I've read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document?
Yes, sir.
Okay, I'm going to go over that document with you. And the document states that following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Hmm.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply in this case, however. Condition number 4 does apply, and it applies because the offense, DWI second, is an offense listed under section 49.04 through 49.06 of the Texas Penal Code. And condition number 4 states, a defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
Yes, sir.
Okay.
But
Yes.
my license is suspended, so I'm not driving.
Okay. Well, this basically says that if you drive or own a vehicle, any vehicle that you own or operate has to have an interlock device in it. Okay.
Yes, sir.
All right. Now, do you understand that condition?
Yes, sir.
Okay. And once you get the interlock, if you are operating a motor vehicle, obviously you have to have the interlock. You need to provide proof to the court. All right. Now, condition number 5 states that the defendant shall obtain, maintain, pay for, and have no violations with the initial interlock device or mobile prep device. Any violation would be grounds for revocation. Now, this paragraph basically states that you have to get a mobile breath device. If you're not operating a vehicle or whatever, you got to get a mobile breath device, okay? And you can provide proof to us within 3 days. Now, number 6, defendant must attend AA/NA meetings 3 times a week and provide proof to the court, okay? Now, do you live in Jefferson County?
No,
You don't?
Orange.
You live in Orange County? Okay. I need to give you some sign-in sheets.
Okay.
The bailiff is gonna give you some sign-in sheets, so anytime that you go to AA/NA meetings, they'll sign, and then when you come back to court, you just bring that with you so we can verify that you've been attending, okay? Okay,
I do have a question, like,
yes,
when do I go to court for this? Because I pled not guilty.
okay, well, we in court
I haven't even
now.
had a chance to plead guilty, no contest or not guilty, but I'm not guilty.
Okay, that's why you're here,
Okay. Okay.
You pled not guilty, and you asked for a, court-appointed attorney.
Yes.
Mr. Rojas has been appointed to represent you. So, any legal questions, you can direct that to Mr. Rojas, and,
So,
he can file whatever necessary paperwork he needs to file on your behalf.
okay.
Okay, he'll have a conference with you, I'm sure he'll do some investigation, and he'll set it appropriately.
Yes.
Okay, all right, just, have a seat in that chair, wait for your name to be called. Once your name is called, you go to the window, and you'll be free to go, and you have a blessed day. You're welcome. Here you go. Okay, did we hear anything from,
Trina said that she contacted his office and he is.
Mr. Atkins? I don't know why license is valid.
It arose off, as I explained to Mr. Atkins, this arose on the same set of property facts as a DWI.
Okay, so the DWI hadn't been filed?
No, sir.
Okay. What he's saying, Mr. Atkins, is that the state is looking at filing another case, DWI. Okay, that happened at the same time that this case happened. And so they're saying that they cannot go forward on this case until the other case is filed. Okay, so it hadn't been filed yet. Now, I could inform you that sometimes these cases, DWI cases, are not filed right away because sometimes there's a lab involved. That means that they have to send either blood or if you had any type of lab done, they have to send that to the laboratory for them to do the testing. And then they can decide how they're gonna file it. Sometimes that takes a while. Okay,
Yes, sir.
so at this point, now you did say that you wanted to waive your right to an attorney and represent yourself. Is that correct?
Yeah, that's because I thought I was just coming for
For the one case?
yes, sir.
Okay, now, since you know now that you're not coming for the one case,
Mhm.
obviously regarding your right to have an attorney, you still have those 3 rights available. You can either hire an attorney. You can see if you can ask, if you cannot afford to hire an attorney, you can ask for an attorney to be appointed to represent you.
Mhm.
Okay, because you already have the other one, which was to waive your right to an attorney. So you know what you want to do.
Mhm.
I can let you,
Really, I wanted to decide when it got closer to the date so I can actually know.
well, we don't know what that day, what that date is gonna be. Okay,
How.
okay, we're gonna get this back to you. You can have, you're gonna make that change. He's gonna make that change.
We doing higher,
Yeah, that's what he's saying.
be the first one. Mark that one off.
Yes. Okay. Okay, now, Mr. Atkins, would you please raise your right hand? Swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Atkins, you may put your hand down. Mr. Atkins, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to hire your own attorney? Now, Mr. Atkins, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Mm.
Okay, Mr. Atkins, I read your answers. Based on your answers, this case will be reset to give you an opportunity to hire your own attorney. Okay, Mr. Atkins, just stand in front of the court coordinator, follow her directions, and once you finish following her directions, you'll be free to go.
Yes, sir.
And you have a blessed day. Ms. Ball, okay? Travis S. Hinkston. You on that one too?
It's okay. It's a nice, yeah, like a whole. Thank you.
Mr. Hinkson, your full name is Travis S. Hinkson.
Yes.
Mr. Hinkson, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Hinkson, you may put your hand down. How are you doing, Mr. Hinkson? I'm doing fine, thanks for asking. Now, Mr. Hinkson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document? And is this your signature on the line that's titled
Yes, sir.
Defendant? Or these your initials on the line that state you like to waive your right of attorney and represent yourself? Okay, now state.
In this matter, Your Honor, it rolls out the same set of operative facts as a felony in which his defense attorney is Carl Parker and Luke Nichols from our office is handling the felony, the associated felony. The next court date is June 1st. We ask that this case continue with the felony, Judge.
Okay, so he has a felony case set on
June
June 1st, is that
yes, sir.
correct? And you said it's out of the same facts?
Oh, yes, sir.
Okay. So basically, Mr. Hingston, what the state is saying is that they can't go forward on this in this case because there's a felony case that is associated with this case. And so they tied them together. Okay? And so they're moving forward on the felony case on June the 1st.
Yeah.
Okay? So this case will also be reset to that same day. Now, let me back up. You said he's represented by Alan Parker?
Yes, sir.
Okay, now, at this point, you still have three options available regarding your right to have an attorney. Number one, you can hire an attorney. Number two, if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you waive your right to an attorney represents yourself.
Yeah, I feel that would pay for the time, but I will represent myself in it.
So you want to continue to represent yourself in here? Okay. Okay, so Mr. Hold on, Kingston. Okay, Mr. Kingston. Oh, excuse me, Hingston. Mr. Hingston, your case is going to be reset. And once your case is reset, you'll be free to go. And you have a blessed day. Please stand in front of the court department. We have anybody else? I see this. We have this lady.
Miss Ledger. But
Leger,
yes, sir. I need to talk to the complaining witness about.
on this one?
Yes, because we got a tentative offer, but I've got to call the complaining witness before.
Okay. Ms. Leger? Ms. Leger, your full name is Jeanette Marie Leger. How do you pronounce it, Leger?
Leisure.
Okay, okay. So I'm from Louisiana. I know that's how they pronounce it over there. Okay. All right. Now, Ms. Leger, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Leger, you may put your hand down. How are you doing, Ms. Leger? That's good. Now, Ms. Leger, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to waive your right to attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on this document? Now, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, Miss Leger, State, would you like to go forward?
Yes, Your Honor. In this case here, we have a tentative
some thought.
offer.
Yes.
However, we are required to contact the complaining witness, given the facts in this case, so related to family violence. So there is a tentative offer that will be tendered to the defendant. However, I do need to contact the complaining witness first.
Okay, now, Ms. Leger, what the prosecutor is saying is by law, they are required to contact the complaining witness in this case prior to giving you an offer on this case. They're required to do that by law. And so he is going to contact the complaining witness. And then he'll get back with you. Your case will be reset. Now, let me ask you this question. How much time?
48 hours.
Oh,
So here's a question.
yes.
If she doesn't answer, what happens?
I will, I have to research the statute, but I do need to make contact with her.
They have to make contact. But they have the means and manner to locate. You can, you can believe that.
Oh, okay. I know she's running from a lawman.
Okay, well, they got investigators in their office, okay?
Okay.
So, yes. Would Friday be, will you be available Friday?
Yeah.
I can reset it for Friday.
Yeah.
Okay, so we're gonna reset it for Friday. And now let me do this here. Before I reset this case, I need to give you some bond conditions.
Don't worry, I ain't going back over there.
Yeah, we just well,
I know, but no,
hold on,
sir.
she's gonna have to make copies.
No, sir.
So I'm gonna go ahead on and give you these bond conditions, and then you can do it right now. Okay, let me sign it.
You did say like, you did say that okay. Like if I had to pay, what do they call that? I ain't never been in trouble.
A fine
Yeah,
and court costs?
yeah, so
Uh,
like that when I stayed in jail, that goes off.
You can
right?
get credit, that can go towards your fine and court costs. You credit at $100 per day.
Okay,
Okay.
I was just wondering. Okay.
Okay. We're gonna make a copy of those bond conditions. I'm gonna go over the bond conditions with you.
Mhm.
And let me do this. Let's show you.
Okay.
Let's
Okay. Okay.
let's shade. Man, where's that?
What about yours?
Here's it.
It's busy.
There it
I
is.
mean, I haven't. And I grilled for the first time by myself. Yay. I got a little letter. Throw some hamburgers.
You have it?
Chicken and snacks. Huh?
Okay, Mr. Lachey, the document that has just been handed to you is titled Standard Bond Conditions in County Court Law Number 2. Do you see that document?
Yes, sir.
And it states, following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are orders subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim, Amber's Schoonover, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Condition number 4 does not apply because that only applies in the DWI case. And condition number 5 does apply. Condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 the Texas Penal Code actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Ms. Leger, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail. Your case is reset until Friday at 9 a.m. And that's, yes, it's gonna be May 29th, 2026. Right? You can get your reset. Once you get your reset, you're free to go and you have a blessed day.
Me too, baby.
All right.
Me too. Thank you.
Okay, well, you can do Sharon. Told him there wasn't, he was like.
Okay, Miss Kelly, Michaela Kelly, Miss Kelly.
Yes, sir.
Okay, now, when do you say you're in Dallas, when you start school?
I start school August 16th.
August, okay, when are you gonna be back down here before school start?
Probably the 14th or 15th.
I need what day of the week could we? That's a weekend.
Yeah, we moving on a weekend. We
Okay,
start school on the 16th.
okay, now do you know what your class schedule?
Not yet.
Cause we'll need you here on the 17th.
On the 17th? Okay, that's fine. I don't, my class schedule now, it'll probably be the same because I do like my classes every Tuesday and Thursday.
The 17th is a Tuesday.
Yeah, I
Is
know.
that? Okay, we'll have her to come in on we'll have you to come in on the 17th then.
Yes, sir.
Okay, she's gonna be on the 17th of August at 9 a.m.
Yes, sir.
Now, let me tell you this here. This does not prevent you from hiring an attorney
Mm-hmm.
if you desire to hire an attorney, okay?
Yes, sir.
So you still can hire one so that they can start working on your case.
Yes, sir.
Okay, but if not, then we have to fill out the paperwork. If you would like to if you think you qualify for a court-appointed attorney, then you would have to fill out the paperwork here, and then we'll see whether or not you qualify. And if you qualify, we'll make the appointment. But again, your case is scheduled for August 17th at 9 a.m. in County Court at Law Number 2 of Jefferson County, Texas.
Yes, sir.
All right, you're free to go.
Thank you.
And one thing about it, I like you have manners. Okay.
Of course.
Now that'll take you a long way in life.
Yes, sir.
Somebody say a good reputation will carry you further than money will bring you.
Amen.
Okay. So you're free to go and you have a blessed day.
You as well. Thank
And
you.
tell your parents they did a good job.
I will.
All
Thank
right.
you.
You're welcome. Court will be in recess till 1:30.